if we look at the recent judicial trend when we are talking about minor pregnancy, one thing is very clear, not just from Supreme Court but across the judiciary, that it is going to be the women's autonomy that is going to prioritize. And that is exactly what we are seeing in front of us when we look at these two news pieces in front of us. One which talks about that how Supreme Court has clearly told that the abortion time limit for minor rape survivors and the pregnancy decision will not be taken by the state. It will be something that will be decided by the individual. So recently, Supreme Court of India allowed the termination of a 30-week pregnancy of a 15-year-old minor girl. And in this pregnancy was unwanted. The girl clearly had expressed that she wanted to terminate the pregnancy, but here the approval did not come, and that is why the court finally had to enter and give the permission to terminate despite crossing the legal limit. So this first news is in regards with that. Then we come to the second news which just came up today, where Supreme Court has gone ahead and further clarified that if AIIMS New Delhi is hesitating to implement the order and if it is not implemented by May 4th, then they are going to be charged by contempt of court. Now this is where both of these bring important discussions in front of us, which we will be taking up today. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh, and in today's session we are going to understand that how in present time Supreme Court is playing out and giving decision to protect women's autonomy, their rights, especially in the cases of minor pregnancy. So when we look at this, the first thing that we need to understand is what exactly has unfolded. So in that context, I have already explained you that what has happened. And the core thing that has been highlighted here, that the court is saying that a woman cannot be forced to carry an unwanted pregnancy, and in this context they wanted AIIMS New Delhi to take immediate action in it, but where they were hesitant, they saw and they also brought in the contempt of court. So the most important thing to discuss more about this is to understand that what is the constitutional foundation around it. So when we are talking about constitutional foundation, the first thing in front of is right to life, that is being talked about in Article 21, which talks about bodily autonomy, reproductive choice, mental and physical integrity, and also dignity, which clearly shows us that women's choice is paramount. And it is paramount above state interest. It is paramount over medical options that are present and the opinion that is being given, and also future of the fetus. So this is something that has been further clarified with what Supreme Court has just said. And this is where it becomes very important for us to go ahead and understand the legal framework as well. And then we will come back to the judicial backbone that is lying in front of us. When we are talking about the legal framework, what do we get to see? That we have MTP Act, that is Medical Termination of Pregnancy of 1971, which was later amended again in 2021. So based on that, up to 20 weeks, what do we get to see? That the termination of pregnancy is allowed with medical opinion, and the opinion will be of only one registered medical practitioner. But after 20 to 24 weeks, this is only allowed for special categories including minors, rape survivors, etc. And the opinion needs to come from one registered doctor. But the moment it goes beyond 24 weeks, this termination of pregnancy can only come with approval of medical board or court. And then in this particular case, what we get to see that the pregnancy is of 30 weeks. That means this can only happen with the approval of medical board or court, and this is where court has used its constitutional power under Article 142. Understood? Now there is another legislation in the legal framework, that is POCSO Act of 2012. Now when we are talking about Protection of Children from Sexual Offences Act, this is applicable to any child of any gender below 18 years, and any pregnancy of minor hair is treated as statutory rape. The consent of minor is absolutely irrelevant based on law, and it also requires mandatory reporting of offences. So in this context, this is something that we get to see that is present as the legal framework. Now when we have this legal framework in front of us, we clearly get to see that there is a defined role of courts versus doctors. So in this, what happened in this particular case, what happened, that Ames argued that fetus is viable at 30 weeks and termination will be very risky, but what court said, that doctors can advise, they can counsel, but they cannot decide for women. So medical opinion is not the final authority in this case, even after the legislation which is present in front of us, and court went ahead and exercised Article 142 and gave their verdict. Now once we have this laid out in front of us, we have already understood that what has happened between Supreme Court and Ames here, and the key principle here is that the reproductive autonomy of the women is above state interest, is above medical opinion, and this is something that is not new. There is judicial backing present to it, judicial historical precedent present to it. For example, Suchita Srivastava versus Chandigarh Administration 2009, reproductive rights are part of Article 21 has been clearly highlighted. Justice K.S. Puttaswamy versus Union of India, a very famous judicial verdict. Can you tell me in the comment section for what was the main right which was brought in detail through this? And this also talked about right to privacy includes decisional autonomy as well. That what do you want to do, your decisional autonomy is part of your right to privacy here. So this was something that has been further laid open by Supreme Court, further clarified once we see this verdict. But another huge angle has come in front of us through contempt of court in this given scenario. So when we look at contempt of court, the one major thing that we have to understand, the whole idea of contempt of court is clearly defined under Contempt of Courts Act of 1971, and there are two types. We have civil contempt, where there is disobedience of any judgment, decree, direction, and in this case this is what is applicable. But we also have criminal contempt, where there is scandalization of court, or there is obstruction of administration of justice, or interfering with judicial proceedings. Now, when we are talking about conditions to prove civil contempt, these are very clearly applicable in this scenario, and as a consequence, fine, imprisonment and institutional accountability can occur if civil contempt is proved, and this is what lies in line for Ames New Delhi. If the termination is not ensured, the order is not complied by May 4th. When we try to understand the ground reality, at present this is not the only case that we need to talk about. We are seeing thousands of minor pregnancy being reported annually. NCRB data has clearly shown that we have high number and unfortunately increased number of POCSO cases, and such sensitive cases not only show delayed reporting, but they also lead to late term pregnancies. So what we are seeing here, that we do have challenges in front of us, not just in terms of lack of awareness, but stigma, medical hesitation, legal delays, which mount up to not just violation of the decisional autonomy, but also the violation of the right to life, right to dignity that needs to be given to the women. Now the question is, what needs to be done in this situation? This situation is a very broad and multi-dimensional issue that stands in our society, and it needs to be tackled in a similar multi-pronged strategy. So what I have in front of you is something that enables the better understanding of reproductive rights that comes with awareness, but also institutional policy level changes that will strengthen the system, that will reduce the stigma and bring better legal clarity as well. So when we are talking about addressing this situation, what should be the way forward? The first thing that we need to ensure is clear medical protocols. There needs to be SOP for how the 24-week beyond cases need to be dealt in terms of viability, in terms of medical, in terms of emergency decisions and more. Fast track judicial mechanism also needs to be enabled for such emergency cases where the timeline is also fast tracked. Apart from that, when we are talking about medical and judicial mechanism, it is also important that there is better coordination between them, better understanding so that smooth execution of orders can take place and there is no misunderstanding in between. Now, this is about institutions. Then we move towards, this is about institutions. Now, then we move towards capacity building and awareness that will happen through better training of medical professionals on MTP, the whole legal framework, not just MTP but also POCSO, and how the autonomy of patient is very important. Doctor is just advisor or counselor, not a decision maker. Furthermore, strengthening child protection, we need to bring in better, effective and real implementation of POCSO so that we have proper early reporting, counseling and also safe shelters put in place, and this needs to be done with awareness and also ensuring accessibility. The implementation of POCSO will not result into anything if the access of this legal framework is not ensured. Now that when we are talking about legal framework, that legal framework needs to come with proper legal clarity. The judicial principles need to be codified that they prioritize women's autonomy while balancing others' interests as well. And if this is put right in terms of awareness and access, there needs to be a direct attempt to reduce the social stigma around it as well. Furthermore, strengthening of medical boards ethically, numerically, ensuring availability and accessibility is something that is going to change the across problem here. And most importantly, non-compliance needs to be handled very well, just like Supreme Court has set an example here. Now that was all from my side. I hope you have a fair clarity on the topic that we have discussed here in detail today. The most important thing that you need to remember here is that such topics are very important from the perspective of not just prelims but also mains. They enhance and help you in answer writing. Let me leave you here with a food for thought. Why do you think in recent times there has been prioritization of a women's autonomy when we are looking at judicial trend? What are the reasons behind it and how can we make sure that it can be balanced with other strategic interests as well? Let me know in the comment section. That was all from my side. Thank you so much.